Every individual should have access to the resources they require from the earth. In ancient times, people gathered what they needed from their surroundings, provided that those items had not already been claimed by someone else. The establishment of ownership and property rights did not eliminate this fundamental entitlement. Thus, it remains essential for individuals to have means of acquiring what they need. This means is trade, enabling individuals to satisfy their needs. Since items are now owned, they cannot be obtained without the owner's approval, and they are typically not free. However, they can be purchased or exchanged for goods of similar value. Therefore, individuals are duty-bound to engage in trade with one another to align with the natural order, and this obligation also applies to entire nations. It is rare for any single location to produce all that humanity requires. One region may have an abundance of grains, another may excel in livestock, while yet another might be rich in timber and minerals. If these regions engage in trade as is natural, no one will lack the necessities and utilities. Furthermore, some areas are more suited to certain products than others, like the suitability of certain lands for vineyards over agriculture. When trade and exchange occur, nations can utilize their resources and labor most efficiently, benefiting all of humanity. Thus, the foundation of mutual obligations for nations to foster commerce is firmly established. Nations should not only promote trade, but also safeguard and encourage it. Maintenance of public infrastructure, ensuring traveler safety, and establishing ports and markets all contribute positively to this end. Where such endeavors incur costs, nations may offset these expenditures through reasonable tariffs and duties. A free environment is conducive to trade, and it is within nations' responsibilities to support commerce without imposing undue restrictions or obstructions. Therefore, private privileges and tolls that burden trade should be rightfully condemned unless they serve significant public interests. Every nation possesses the natural liberty to trade with those willing to engage, and any interference with this right is an infringement. For instance, during their period of dominance in the East Indies, the Portuguese attempted to exclude other European nations from trading with the Indians. This unjust and unrealistic claim was rightfully dismissed, leading other nations to view any aggressive action supporting it as justifiable grounds for war. Today, this principle of freedom in trade is widely recognized. While nations are generally expected to engage in commerce with one another, they also have the right to refrain from trading when it may be detrimental or risky. In cases where interests conflict, a nation's obligations to itself take precedence over those to others, allowing it to make decisions based on its own safety and benefit. Each nation determines what trade practices are suitable for itself, enabling it to accept or decline foreign trade proposals without unjustifiably facing accusations or compulsion. Trading with other nations is an imperfect obligation, meaning that if such trade proves harmful, the obligation ceases to exist. Historical examples, such as the Spanish conquest of the Americas under the pretense of trade refusals, illustrate the exploitation of such situations out of greed. These observations provide a clear understanding of the duties nations have regarding mutual commerce. While it's relatively straightforward to define these duties, and the natural laws guiding them for the benefit of humanity, each nation is primarily responsible for determining its own course of action in trade. Therefore, nations often rely on treaties to secure consistent benefits, as each has the right to regulate its commercial relations based on what is advantageous to them. Nations can enter into treaties that govern commercial relationships, as long as these agreements do not infringe on the absolute rights of others. If a nation engages in trade that serves its interests, it acts within its rights, provided that such actions do not hinder the overall commerce of nations. Hence, nations must respect each other's decisions, and assume that they have valid reasons for their trade practices. Commercial treaties that do not violate the rights of others are entirely acceptable, and their enforcement cannot be justly challenged. However, it is critical that nations carefully evaluate any treaty before entering into it, ensuring that they do not compromise their own rights or responsibilities to others. Nations have the freedom to set the terms of their treaties, whether they are temporary or indefinite, and the most prudent approach is often to avoid lifelong commitments due to potential future changes in circumstances. A nation may limit a treaty to grant only a conditional right, preserving its ability to withdraw from the agreement if desired. Once a nation commits to a treaty, it cannot later engage in actions contrary to that agreement that it might otherwise have undertaken for humanitarian reasons, or the general obligation of trade. For instance, If a nation agrees to supply a specific good exclusively to another, it cannot sell that good to anyone else. The same logic applies to agreements to purchase goods solely from a particular nation. A nation may choose to enter into agreements that limit its trade with others if such agreements serve its safety or significant benefits. This is justified, especially if it does not disrupt the general trade of nations, but rather directs specific trade flows. For example, if a nation reliant on salt secures a reliable supply from another nation in exchange for corn and livestock, it acts within its rights to establish such a beneficial treaty. Nations may of course relinquish certain trade rights in favor of another nation and agree not to engage in trade with specified regions or products. Violating such commitments would be contrary to the established rights of the contracting party, which would then be entitled to enforce the treaty. The inherent right to trade remains intact, as it consists of a nation's ability to conduct commerce with consenting partners while retaining the freedom to enter or exit specific trade agreements as deemed beneficial. Nations engage in trade not only for necessary resources but also to generate wealth. As profit opportunities arise, it is lawful for any nation to pursue them. The diligent may claim advantages as they arise, even monopolizing them if done lawfully. Thus, if one nation controls certain goods, another may negotiate exclusive purchasing rights through treaties, subsequently reselling those goods globally. Provided that prices remain reasonable, such monopolies do not conflict with the broader duties of humanity. However, if a nation abuses its monopoly by charging exorbitant prices for essential goods, it violates natural law and may prompt a collective response from other nations to ensure fair access. The institution of consuls serves as a valuable asset for international trade. These representatives reside in major trading cities and ports to safeguard their nation's rights and resolve disputes among merchants. When a nation engages significantly in trade with another, it is essential to have a representative to oversee these affairs, and the host nation is likely to welcome this consul. While there is no absolute obligation to appoint a consul, a nation seeking one must negotiate this right through a commercial treaty. The consul acts on behalf of their sovereign and remains accountable to them for their actions. Although a consul does not have the same diplomatic status as a public minister, they are entitled to certain protections under international law granted by the host nation upon their acceptance. The role of the consul necessitates that they are not a citizen of the host state to maintain their independence in fulfilling their duties. Ideally, they should be exempt from ordinary legal proceedings, unless they commit a serious breach of international law. Although a consul does not enjoy the same inviolability as public ministers, their sovereign's protection implies that serious violations warrant their repatriation for accountability. In the absence of treaties, customary practices govern the relationship between consuls and host states. If a nation receives a consul without explicit conditions, it is understood to be under customary agreements. Historical incidents, such as the grievances raised by the Dutch and the Venetians regarding the treatment of their consuls, illustrate the recognition of such customary protections under international law. Thanks for watching. Don't forget to subscribe for more educational content on international trade and history. Check out these related videos to continue learning about global commerce and diplomatic relations.